uh, when the constitution was enforced in the India. After that, in 1952, the government of India felt necessary that there should be some kind of schemes for the poor person. In criminal procedure, civil procedure code, then provisions which enables an indigent or the poor person to apply for legal aid. But it was not so much helpful. So, the government of India given a task to the Law Commission, the 14th Law Commission, to look into the matters. That commission particularly focused on the reforms in the court administration. And also suggested the setting up of legal aid clinics and legal aid. The pioneer of the protector or the procedures of the rights of people, Justice Bhagwati and Justice Krishna Iyer, were also in favor to set up a mechanism for the legal aid programs, for the legal aid, so that it can be legitimized. So that it can be given to the common man to reach the authority for the legal assistance. The term legal assistance and legal aid seems to be synonymous to each other. But as I have read about it for the two terms, I may conclude that legal assistance is used in the pecuniary term, means providing monetary assistance and not more than that. But legal aid have or can be said that the person who are seeking the help to file the case, to be filed, fought by the advocate, as well as assisted in monetary term. So, this is a little bit, may say, कि हाँ ये उससे थोड़ा ज्यादा वाइडर टर्म में यूज किया जा सकता है. दिस इज माई क्रिटिकल और कहेंगे कि that I have concluded it from my reasoning. When I go through the, when I have gone through the provisions of the Britain, USA, and the French legal system. Justice Bhagwati in the committee for implementing legal aid schemes observed and supervised the legal aid programs around the countries in 1980s. And that committee introduced the Lok Adalat system. The alternative resolution system, where the consenting party can resolve their cases amicably before the Lok Adalat. Thereafter, in 1987, the Legal Service Authority Act was made, and in 1995, according to the provision of the 1987 Act, which was enforced in 1995 November, the National Legal Service Authority was created. Now come to the points where we could discuss about the importance of the legal aid, who can file for the legal aid, in what cases legal aid can be provided, in what cases that cannot be given, and when the legal aid services can be withdrawn, and who can or who is are eligible to take legal aid services. So now let us discuss it. Who can file application for the legal help? Overall, एक एक एरिया जो मैं मिस कर गया इसमें ड्यू टू द इंटरप्शन इन द डिस्कशन, that was the international provisions convention, declarations, commitment related to the legal aid. Before going forward in the particular lecture, I would like to briefly mention about the development of legal aid in the international perspective. United Nations Declaration of Human Rights, that is popularly known as in the short form UDHR, proclaim rights of the people without any discriminations. What are the commitment adopted by the state in this particular declaration? What was that? It was the preservance of inherent dignity and equal and inalienable rights of all members, as well as the freedom of speech expressions were taken as a highest aspiration. It declares that human rights should be protected on the basis of the principle of law, rule of law. Women and men should be treated equally. And the member states are pledging, taking oath. This is not only the oath like before the God, but to the preservance and protection of the human right in accordance with the acceptable legal principles and on the basis of the constitutional law of the land. So that the human right can be universally respected. And state in their relation will also take care of such human rights. And the derivative of such rights were further recognized in the Civil and Political Rights, Convention of the Civil and Political Rights, and the Convention on the Economic, Social and Cultural Rights. And there are several other documents related to the recognition and preservance of the rights, like Convention on Elimination or on all form of discrimination against women, and Convention on the Child Rights, disabled persons, migrant persons, refugees, internally displaced persons, etc. They are the special groups. They are due to their social stigma or social discriminations are unable to access and enjoy all the rights given to the men. Due to their social, political, or economic conditions, they are unable to enjoy such rights. So that special treatment should be given. Further, the European Convention of the Human Rights also recognize to protect the right of the people and to give legal assistance in case where he cannot afford it. So Article 6 of the said convention provide that everyone charged with the criminal offense has the following right. What are the rights? Right to defend himself in person or through legal assistance of his own choosing. Legal assistance of his own choosing is important. Or if he has no sufficient mean to pay for legal assistance to be given in free when the interest of justice so requires. Here is an idea on what basis the legal aid can be given. In most of the countries, two tests are performed. Even in the Legal Aid Service Act 1987, it is also given in the section 13. 12 enumerate the peoples who can access the legal aid. 13 said what are their economic conditions, means to pass the means test, means sadhan test. And second, that it should also pass the prima facie test. That such case is eligible on prima facie basis for the legal aid. That I will also discuss is which is eligible and which is not eligible. There is another convention for the migrant workers, which also said about the legal assistance for justice, and American conventions of human rights also say about the assistance to the indigent person. So everywhere we could find that poor person, needy person should be taken care of by the government in the legal proceedings. Otherwise, as I already told, that such right of the people cannot give them proper justice. A special convention convention and guideline were provided by the United Nations in 2012 regarding the legal aid system for the development of the legal aid in the civil matter and in the criminal matter. On the other hand, a special rapporteur on the extreme poverty in its report in 2012 also given the importance of access to legal aid services for civil matter in addition to the criminal matters. So it recognized the civil as well as in the criminal matters, both. Now come to the provisions of the Constitution. Of India, which provide equality before law and the Article 21 the establishes the fundamental right to life and liberty, which was later under it the concept of free legal aid was decided by the court. Article 21, Clause 1 establishes the right of an accused person to consult at an advocate of his own choice. Whereas, on the other hand, the directive principle, Article 39A, provide, which was added in 1942 amendment, 42nd amendment. It is the obligation of the state to see that the legal system advance justice based on equal opportunity. It should give free legal aid to all the individuals who are eligible. Eligibility based on the finance as well as on the basis of disability. Conditions. And such whole idea of providing justice to the poorer person of the society may also be seen in the Article 142, Clause
ठीक।
आ रहे हैं भास्कर जी, कोई प्रॉब्लम हो गया टेक्निकल उनको। और नेटवर्क इशू है या जस्ट ज्वाइनिंग?
हेलो।
हाँ हेलो, यू आर ऑडिबल।
थैंक यू। यस मैम, थोड़ा सा वो टेंशन हो गया।
देयर आर सो
मैम
मेनी टेक्निकल ग्लिचेस या
आज ग्लिचेस बहुत ज्यादा हो गए कुछ।
हाँ, ये मौसम इज आल्सो नॉट गुड ना, वेदर का भी प्रॉब्लम है थोड़ा।
जी। So I am discussing about the constitutional provision of the legal acts. Now, particularly I want to discuss the provisions of the uh, legal act, this act 1987, which says that according to the section 12 of the act, it mentioned that the following people are eligible under the category. These are SC/ST community, member of the ST/ST community, victim of the trafficking in human, woman, child, a disabled person including mental disability, a victim of mass disaster, ethnic violence and caste atrocities, flood, drought, earthquake or industrial disaster, a person who is in the custody, are eligible to apply for the legal aid. We closely look into the category of the people. We could categorize them according to the discrimination और पर्सन इन कस्टडी की बात छोड़, तो सोशल डिस्क्रिमिनेशन में
चला गया इनका तो। ओफो, क्या करें, वाइंड अप करना पड़ेगा क्या?
मैम आवाज भी साफ नहीं आ रही है सबकी।
हाँ, आज तो बहुत प्रॉब्लम थी।
Okay, so the woman, child, and ST discriminated on the basis of social status, along with the disabled person. Disabled person have their own problems due to the physical disability, and the person who are in custody have a constitutional provision in favor of them for legal aid. If we take them, these category of persons on the basis of vulnerability, what is vulnerability? It is the word derived from a Latin word, which is, it means wound. The person who is injured, injury that is physical, mental, psychological, economic, or institutional. And these are not the only injuries. That may be different other kind of injuries. There may be other kind of. That vulnerability can also be categorized on the basis of particularization or on the basis of oversight. If we look the case of the Chapman versus United Kingdom, registered popularly known as Roma ethnic case, which described the characteristic of the vulnerable group on the basis of relational or the particular, the basis of harm based. So first is that conceptual, relational and particular. Second is harm based. Next is the social disadvantages and the material deprivation, prejudice and stigmatization. Roma communities was prejudiced and stigmatized on the basis of ethnic, डिस्क्रिमिनेशन, उनका कल्चर, उनके ट्रेडिशन डिफरेंट रहे, एंड द अदर ग्रुप जो, मेरी आवाज आ रही है?
जी आ रही सर, आ रही है।
जी सर। Indigenous people in India, or the tribals, and the people who are or who do not believe in God, atheist persons, were also a kind of people who are facing the discrimination by the other communities. So vulnerability can not be defined in a particular term. In particular section, it is a very wide concept. एक व्यक्ति के उनके अधिकारों का जो हनन है वो पूर्ण रूप से किसी एक शब्दों में नहीं कहा जा सकता, उसके लिए कई आयाम हैं जिनको देखना पड़ता है। That is why the section 12 of the SLS services provided the different category of people. Now, I would like to discuss the important cases in which the legal aid was declared as a right. M.S. Hoscott versus the State of Maharashtra in 1978. In this, the Justice Krishna decided that the code under Article 152 and Article 21 and Article 39A of the Constitution has the power to assign counsel to the imprisoned person for doing complete justice. Later on in 1979, Hussain Khatun case, the court held that so that it is the duty of the state to provide counsel for protection. Similarly, after in Khatri versus State of Bihar, also said that the free legal act should be borne on the state, the cost on the state. Sukhdas and the Anokhi Lal case. Sukhdas versus Arunachal Pradesh and the Anokhi Lal versus the state of Madhya Pradesh. In the said case, Anokhi Lal, the court held that कि सिर्फ इतना ही पर्याप्त नहीं है कि काउंसिल असाइन कर दिया गया है, बल्कि काउंसिल को उतना adequate time should be allotted, should be given, so that he can properly make the representation. In Sukhdas case, the court held that magistrate must inform the access to free legal aid to their people. Now, in both these cases, if the court has not worked according to the provision, could this proceeding be vitiated? क्या वह प्रक्रिया विटिएट कर देगी प्रोसीडिंग को? The court held that if the whole proceeding during the trial the defendant is under prejudice, the proceedings can be vitiated, can proceed vitiate the proceeding, overall proceeding, trial process. अगर हम इस बात को भी देखें कि क्या राइट टू वुमेन, राइट टू चिल्ड्रन, डिसेबल्ड पर्सन एंड द पर्सन हु वर बहुत ही कम मात्रा में जिनको किया जाता था, वो जैसे कि एलजीबीटी ग्रुप्स हैं, उसके राइट्स का क्या प्रोटेक्शन दिया है. So we could find the different judgments of the court in this year up to the 2018, 17, 18, now tasting job, and in the Puttaswamy cases where in notation the consensual homosexuality was accepted by the court, and in Puttaswamy, other hand, the right to privacy was also set as a principle. as a fundamental right. Now, the HIV groups, the AIDS patients, are also vulnerable in the society due to the discrimination. This, the disease, particular disease है, उसको एक सोशल स्टिग्मा के रूप में भी देखा जाता है. तो अगर उनके राइट का वायलेशन हो, whether they can claim for the legal aid or not. The affirmative, the answer is in affirmation. Groups which are mentioned under the section 12 do not include specifically these groups, these persons, those persons. So, the section 12 should be expanded according to the need of the development in the legal field. Now, at last, I cannot share on this mobile because my slides are in the laptop. कि कुछ ऐसी थी कि जिसमें हम डाटा को इंटरप्रेट कर कर बता सकते हैं. तो काफ़ी डिस्टरबेंस हुआ है बीच में और आई हैव टेकन टू मच टाइम. आई legal aid, please, and and all the faculty members of the department for giving such an opportunity to discuss various aspects of the legal aid. And I'm Siraj. Thank you so much. Am I audible?
Yes, sir.
Jitendra?
Your voice is not coming, Dr. Bhaskar.
Hello, ma'am. Hello.
You are not audible.
Hello. 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 हेलो हेलो
आवाज आ रही है
You
सर?
are not audible at all, Dr. Bhaskar.
Am I
Wind up now.
हेलो
You may write in the chat box what is the problem here.
यस मैम
Very sorry today. There are so many technical glitches. Okay. Now Dr. Bhaskar has conveyed his thanks to all. So now it is time to wind up. And today there was so much problem regarding technicality on the Gmail. So it was interrupted, and then the voice is also not clearly audible. So on some other time, we will be hearing to Dr. Bhaskar. Am I audible?
यस
Yes, ma'am.
Am I audible?
यस मैम आ रही मेरी आवाज आ रही यस मैम यू आर ऑडिबल
Anybody please respond.
आ रही मैम, आवाज आ
Am
रही
I
है आपको?
audible?
Yes, ma'am.